G'day, Kim.
Hi, Andrew. How are we?
Another terrifying day in front of the video.
It'd be all right if I didn't have such a headache, but we'll see how we go.
Well, 3 glasses of wine is a very dangerous thing.
It's my body telling me
It is.
more.
Oh, no, yeah, my body told me that, but I've got 2 hands. One I can control, the other I can't. I don't know what it is. Okay, there's a couple of things I wanted to chat about quickly before we really get into this. I guess a lot of people have forgotten new delegates' right regime has come in.
1st of July.
1st of July, yeah. So, and we've had already 2 or 3 questions about the nature of a support person. And can I just be clear about this? If you've got an enterprise agreement, you must have a delegates' rights clause.
Yeah.
And if the support person is a delegate, then they have the entitlements under delegates' rights under 350 C of the Fair Work Act.
Yeah.
You're like, oh, I remember that, didn't I? That's very good. Yeah, I did. So what I want you to remember is a support person who's a support person who's a support person. In other words, not a delegate, is a person who's there to provide support, emotional, participate in giving a hand to the person, but they're not an advocate.
No.
And they can't control
speak on their behalf.
Can't speak on their behalf. But if the person's a delegate, they're a delegate, even if they're not acting like one, even if they turn up and say they're a support person, if there's a right of representation or they are a delegate, then they're a delegate for the purpose of the Fair Work Act, and therefore they do have powers to be an advocate and representative.
Yeah. Okay. So what do you think about having the dispute procedure within an EA? Do you think that's a good idea? And differentiate between
the dispute procedure is absolutely critical. You've got to have one in, actually. It's a mandatory term, but you don't need to have, and you should not have, discipline and performance management enterprise agreement.
Right.
You should not have it because the less you prescribe it, the greater flexibility you actually have. Yeah. So even in policies and procedures, they shouldn't be pages. They should give you absolute discretion on the manner in which you behave. They shouldn't have 3 layers of warnings and all that crap. But if you put it inside an enterprise agreement, you're stuck with it, and you fail to follow it, it's actually a breach, which is a civil penalty offence. Yeah. So you give the union an extra tool to fight you. So that's one. The other thing I want to chat, which you know nothing about, is we've seen probably one of the most appalling pieces of management with the West Coast Eagles and Adam Simpson, where it was very clear that there was a group of supporters, possibly with a very red-coloured neck, who didn't like him much. Their second most successful coach ever, I might add. He may not have been performing, and maybe it's right that he leaves. But wouldn't you just say to him, Adam, could you resign, serve out the year, we'll find a replacement, could you help somebody come through and make it look like it was his decision and respectful, and then celebrate this person? And instead of that, you have a CEO who doesn't tell him whether he's coaching the next game or not, who makes it very public it's by mutual, which means I've sacked you. So he appeals to his audience. And in doing so, you damage the leadership group of the team who were totally behind him. And you play this terrible thing that happens in football clubs where everyone wants to be in the media because that's what football's about, and everyone forgets that treating people respectfully is the most important thing to do. And when we see executive issues where we're moving someone on, Kim and I always go, don't reach for the sword. There's so many better ways to do this, because that person has a group of people who sit beneath them who want to feel safe. Employees want to say, if you deal with your boss that way, then maybe you deal with me this way. But if you decide to go out with I'm a tough guy, I can sack someone because I've got power, then you reap what you sow, and you lose the trust of people and suppliers and everybody else around you. So I think really good lessons from that story, and I feel very sorry for him that he's been treated so poorly. But you don't have to behave like that. Anyway, so let's jump on to the first case. This is Lavery and Northern Territory stolen generation. This is sort of a classic case, really. This is a person who was given an incredibly difficult task to do, dealing with groups of people who were vulnerable and didn't have the skills in the first place. So badly recruited for a role, probably didn't go wonderfully well. They said to them, you're not going very well, but then didn't deal with it in the performance review at all.
No, didn't provide them any feedback or training to support them in the role as well.
And then raised general allegations without saying who, what, when or why. It's pretty terrible, isn't it, really?
Said to someone, you're not performing well, we've received complaints about you, provided no allegations or detail of the complaint, just said we're standing you down pending an investigation, never had an opportunity to respond to the allegations, and terminated their employment. So naturally, they succeeded in their unfair dismissal claim.
I just think such a good lesson, because so often while people are trying to be trying to be nice to people. You know, I'm not going to say what the complainant said. It's a bit rough. I don't want the complainant to feel scared either. This all turned out to be one person gossiping.
Yeah.
That's what this whole case, thousands of dollars wasted in this case, was about them listening to a person, not verifying it, gossiping about what this person did to a number of people, but never putting the allegations in a formal way to the person. It's just terrible. Anyway, let's move on.
And we'll touch on that in our main
Yeah, we will
well.
touch on it again. Now, we're on to impulsive resignation time. So
I like these ones.
Yeah, Mr. Thad Pillar.
Yeah.
That's his name. Interesting man. He came to the Fair Work Commission and said, as a Nepalese man working for an Indigenous organisation, it would not be fair to me if an Indigenous person or a white person were to judge me.
Yeah.
And then failed to raise any allegation of cultural sensitivity throughout the entire hearing.
Yeah.
He resigned and over a period of a couple of days made it very clear he had resigned. And so obviously this is an argument as to whether he was employed, whether he resigned for general protections claim, therefore no jurisdiction, or was a jurisdiction. And the court looked at it and said, no, you resigned. And it wasn't said in the case, but the rule in Brown and Dunn is a decision I want you to know about, which is what it says is you can't raise an allegation in cross-examination that you haven't led in chief. That's the rule, okay? Lots of people fall foul of it. They make a big song and dance about something, then don't lead the evidence. And in this case, although that wasn't the direct law, it sort of was in a way, because he didn't lead any issues of discrimination or complaint around the manner in which he was treated in his own evidence. And so the Fair Work Commission sort of looked at him and said, I actually don't really know why you're here, and dismissed it all. Yeah. Okay, I know you practiced very hard to say some things. I'm talking all the way through it, but I thought I'd give you a helping hand. Can I just say about impulsive decision-making in resignation, it's really important to understand. Kim cracks it with me, storms out. It's quite possible, by the way. She's a bit hungover.
I haven't.
Right? But it could
just to make that clear.
Hungover, just saying. If she cracked it, left the room and said, stick it up your bum, I'm going.
I'm out of here?
Yeah. And she turns up the next day and I go, oh, you resigned. I sent an email saying, I accept your resignation, you hungover nasty person. That would be in what's called in the heat of moment resignation, and it would not be termination. No. Okay. But here, not only did the person do it in the heat of the moment impulsively, they then confirmed it over a text and an email. And in a call. Yeah, in a call. So we've done a number of heat of the moment type things where someone repeats that process. The impulsivity is gone, the heat has been taken away, and it is deliberate. And at that stage, you do accept it, okay, and you will be successful with it. Why don't we talk about the worst decision I've ever read? Okay, Arnott and Safe.
We read a few of those.
Oh, well, this is just such a shitful decision. Arnott and Safe Work, New South Wales. What a case this is. So this is an HSR whose work group extended over a number of sites. And part of his obligation as an HSR was to go and do audits around those sites, and he couldn't get them done in his work time. Are you starting to feel the vomit getting in the back of your throat at this stage? So without telling them, he did it out of hours and asked to be paid for it. And wait for it. He succeeded. So there's two lessons in this. One, appeal. Two, when you've got someone who's an HSR, make sure their work group is limited to the place where they're geographically working, and the role and responsibility is of a limited area. It's not bad to have 10 rather than 2 HSRs, but there is an argument that sits inside this case which backs the decision, okay? But part of it is just really poor business administration that allows work groups to be of such size geographically that this can occur, because people are scared of industrialising processes. Well, it's better to refract it and have little sites rather than one site and have someone getting paid all this extra time for doing it. The other part is somebody should have sat down with him and said, look, what's happening with your audit process over the next month? So there is some clarity around it, because what the court did say, or the bench did say, not very well, but what it did say is they can't abuse this right. Well, if you don't sit down with them and find out what they're going to do, they're going to do it, and you can't say it's abuse. So there's some structural stuff about this case in HSRs I want you to think about. I do want you to go and read it if you're having trouble sleeping. but it's not the best law I've ever seen. Okay, Kolofsky and Opal.
Oh, this is, yeah.
Come on, you do this one.
Okay, I'll do this one. So another unfair dismissal claim. We had a safety incident with a forklift, and the driver advised after the incident, it said, this is the reason that the accident occurred.
Brake failure,
and also questioned the service history of the forklift. But Opal terminated him before that. Again, just didn't do a thorough investigation.
Oh, and they relied on what Adaptalift said as the investigator. It was worse.
Yeah. So
the person who was being criticised by the worker was the person who undertook the review, and there were anomalies with the brakes, which were unspecified.
Yeah.
But Opal didn't wait. And again,
and they could have.
They could have. Yeah. But the problem, softened narratives form very quickly when incidents occur, particularly, we look at 9 out of the 13 industrial manslaughter, I think it's up to 14 now, and I can't remember what the 14th was, are mobile plant. So in safety terms, this is the highest risk thing, sitting on a floor of an Opal factory, most dangerous thing about. So clearly when they do make a mistake, and if you don't trust the person and that's your experience with them, you'll form a very quick view. And you might be right and you might be wrong, but if they are that person who's difficult, this person's been reinstated. Yeah. This person is now unsackable, effectively. So time, reflection, and when someone raises an issue that explains something that occurs, you must investigate that and satisfy yourself with the truth or otherwise before you move to the disciplinary process. And certainly not rely on someone who has a self-interest in saying it's not true. Yeah. Okay?
All these cases fall over when there's just a lack of procedural investigation.
There is, yeah. Okay, what about Westpac? Can I say to you, 20 years ago, I just had a fire drill at the Royal Children's Hospital this morning, which was really interesting to watch because it was identical to what occurred back in another building 20 or 25 years ago, where everybody moved towards places. Nobody knew what they were doing, even though it was a drill. What was said over the loud hailer wasn't understandable. But where I was 25 years ago, a woman had a heart attack on about floor 13 coming down from floor 20. So I just want you to understand, in this case, this is a compensable injury of somebody going down a stairwell and blowing their knee out. Yeah. And pathologically, it was clear there was a precise injury, and so it was compensable under workers' comp. That's the short. But what I want you to understand is, when you've got workers in a place who are physically particularly unfit, and you're looking at inherent requirements, one of them is they can leave the building safely. I know you might think I'm being a bit tough on that, but the short answer is, do you really want to kill someone in an emergency? Not by the emergency. And here we've got an example of someone who may not have been like the poor woman who was involved and who survived, I might add, but repeatedly in drills where people evacuate buildings going down in multi-storey buildings, there are significant problems that arise. Some are just breathlessness, some are heart problems, some are all sorts of things that occur with it. I just want you to understand that is part of the inherent requirements of the job. And so when you notice someone is extraordinarily unfit, they have health-related issues, you do need to address it. Yeah. Okay? Otherwise, it is compensable, but worse than that, you're killing someone when you shouldn't. And so on the moral level, I know it's a hard conversation, but you sort of got to have it. Crazy Comcare fines. Can someone tell me why Comcare, who mainly works for government, has 5 times the level of fine for state and territory fines for non-Comcare people in reckless endangerment? Now, that's just rubbish. $18 million fine for reckless endangerment compared to 3 to 5 in other states. Yeah. I'm only raising it because it just blows my mind. It's sort of, why would you take more money from your own government? I'm not sure I understand that. It just, why do we have this system where we actually don't have a national system, where someone goes ahead and creates a set of penalties which is so abstract from every other state? You look at them and go, is there a good reason to disagree with everyone else? And the answer is no. You're just being a dick. Anyway, so that's them, Comcare, out there. Why don't we hit the main topic?
All right. I might get a word in.
Yeah, look, our main topic today really is around investigations, which Kim particularly does lots of. And we just got a lovely case that's come through with Majanowski and BlueScope Steel, which I'll let Kim talk about. But I want you to think about, how do we do investigations? So very simply, we can't begin an investigation until we have a dedicated set of allegations. The law on allegations is very, very clear. It must identify the fact, when, where, and who must understand that. And it must be something that a person can respond to. So the second part of it is, it has sufficient particularity that a person presented that allegation is able to say, I wasn't there that day. I was actually in Papua New Guinea. I was whatever. So if you can just remember, that is the beginning of all investigations. The second part is, do you always need to investigate something, or could you just bring people into the room and talk to them about it? So it's based on the seriousness of it. And when you hear these facts, one of the questions you just couldn't help asking yourself is, if it was true, it was a terrible thing, but why didn't you get everyone in the room and just say, look, tell us? And if you did say it, why'd you say it? I don't know, that's sort of where I was with it. But anyway, Kim, over to you.
Well, in this case, we just had the employer decided that it needed to protect this young complainant. And so they didn't even speak to him. So he raised a safety issue, or he alleged to his manager that another colleague had threatened him and yelled at him. But the employer, when investigating it, just relied on the statement that he gave to the manager without actually testing the veracity of his evidence in order to protect him.
Can I say this is sort of psychological hazards gone crazy?
Yeah.
Somebody with some mad well-being tilt thought, ooh, we won't speak to anybody about what they said in case we hurt them. Can I just say, you don't assume it's true. So both the alleged victim and the respondent, you treat the same at the very beginning, always the same. So how could you ever think it's such a nice well-being thing not to tell the person you allege it against, who it hurts and would have a good compensable claim here by them workers' comp, the truth? Why wouldn't you do it? Because you're so focused on the bloody victim and you're trying to be such a do-gooder that you forget maybe there's a proper way of doing this. Anyway, you can see I'm unimpressed with this. And I smell well-being sitting in the background being misused again. Because it's quite serious. This is a guy who said somebody leaned out of the window of their car, yelled a terrible abuse at them, came and immediately complained about it. Not only did they not take a witness statement from the person involved, they didn't check the veracity of the allegation with them, and they didn't ask them to come to court. Now, that sort of dumbass stuff is just beyond belief, really. And I'm sure that nobody except the person who was silly enough to do that was surprised by it. Because if Kim and I fall out, but we're employees, I would expect Rob as the CEO to treat us exactly the same until he found out what the truth was. And then, because I was bad, I might cop a whack. But all the way through, I must be treated the same as Kim, which means I must be given respect, I must be offered support, I must do all that. But none of that happened. They just took a victim's side and they hadn't even talked to them. Extraordinary, isn't it?
And this guy was reinstated, which
Yeah.
makes it even worse.
I know, because if it's true, again, unsackable. Absolutely unsackable. So we raised it today really to agitate these issues. And I know we keep doing it, but we keep getting investigations brought to us that have the same flaws. First thing is, you don't have to have a complainant. You can, under safety legislation or discrimination legislation, say, we as a business raise this matter with you. You can't hide from who it occurred to or when it occurred or what it was. So you can't hide from that. And you actually have an obligation under safety law and workplace law to provide that level of precision. Once you've done that and you've got an allegations letter together, then you can take that to a person and workers' comp, you say to that person, I need to chat to you because there's a complaint. If you want to have someone present, workers' comp, not any other form of law, because workers' comp is Gumby law, but nonetheless, and you present it to them and say, look, we're going to chat about this in a couple of days' time. If you'd like a support person or a delegate, you're very welcome to bring them. If you're going to stand them down, you can only do it on the basis of there is a reasonable basis for thinking that they're going to impair the investigation through their behaviour, or it's such a serious thing that it's a safety issue. Okay, only 2 reasons. And then you go about the process in a mechanically and good way of actually presenting the allegations to a number of witnesses, telling them it has to remain confidential. getting their first-person evidence, not cross-examining on them, so that you're getting their best record of what occurred, collecting it together before you take it all then back to the respondent and say, all right, this is where we are, this is the final cut of where you are, please respond to it, allowing that person to have a support person, providing them with EAP support if they want it. None of that's hard.
No.
And yes, it's important you get through it quickly, but cutting corners in investigation is just cruel. Because what you're really saying to a person is, I know you're guilty. That's what you're saying to them. Whereas an investigation done well tells a very good story beyond the group that's there, that when this business believes there could be a problem, they treat people fairly. They're very candid about them. They listen carefully to them. They make all the inquiries. So I'm the respondent. I say, but that's not true because Kim was doing A, B, and C, and she was actually over that part of the room. Well, then you need to go back and check that's true or not true. You can't just go, it's Andrew, he always makes shit up. You can't do it. That's before you even get to discipline. But once you've got a series of factual findings against an allegations letter, you can then safely proceed to discipline. But you've got to have exhausted the process. Not just cut corners.
Because if not, you're leaving yourself exposed when you do discipline someone unfairly.
Well, you're gone. And, you know, the case law, common law, talks about natural justice, that you must, and to give someone natural justice, it's to satisfy that person that you've considered what could you've considered what are the allegations, you've created them in a way that can respond in a reasonable time and in safe circumstances. You've allowed them to respond fully. You've gone and investigated what they've said, and then based on the Briginshaw tests of balance of probabilities, you've made a set of findings. Now, that's the common law, but you've got a provision under the Fair Work Act that actually requires you to have a higher level of fairness, which is procedural fairness, which means that each step along the pathway must be correct. So natural justice is a broad general concept of what is fair. Procedural fairness is natural justice on steroids. You must do this, you must do this, you must do... And if you breach any of those, you fall over on the termination, you fall over on workers' compensation, you fall over on safety law. So you fall over everywhere. So look, I think a really helpful case, personally. And as I said, I think we need to be a bit careful of the well-meaning. That's a word my father used to describe people who are incompetent. They're well-meaning. But the well-meaning people who think, I must look after the victim. Well, can I just tell you, that's not your job. Your job is to look after all your employees. And your job is not to form a view before you're satisfied with facts that you should be. So well-meaning people, keep away, please. Just let's do what lawfully is required, because that is actually well-being, doing what is required to be done properly and generously. That's well-being. Okay?
Yep, good. You've got a good result.
Okay, let's go on to the case study. Okay. Let's test you out. Kim, over to you.
Okay, Nancy felt alone. She was sitting in an office with no windows in the basement. She'd been summoned there by Denise, the head of people and culture, 20 minutes before. Denise had met her at the door of the office, invited her in and went to get them coffee. When Denise arrived back with 2 mugs of instant coffee...
you know how much I hate Denise? When I wrote that, I hated Denise. I just want you to know, because if someone did that, I'd just throw it on the ground. Anyway, coffee. You can tell Denise is in trouble, by the way.
Anyway, Denise comes back and she reassured Nancy she had nothing to worry about, but Nancy was worried. Denise said there had been a complaint about Nancy's attitude to her co-workers. Nancy asked who complained. Denise said there was no specific complainant, but we as a business are raising this issue with you. Nancy asked who had she shown bad attitude towards and what did it look like. Denise just said to several staff, they don't feel safe saying who they are, but on numerous occasions over the last 2 weeks, you have called some of them idiots, scowled at them, rolled your eyes and sworn under your breath. Nancy was at first shocked, but then started to laugh. She said, so I did all these things, but you won't say when, to who, and what were the circumstances. How can this be fair? How are my interests protected in all of this? What about how I feel? I feel scared. Doing all of this to me, are you shitting me? Got to do it. You make me swear every single time to do this to Nina, honestly.
I do, but she doesn't do it.
Denise said for Nancy to hold her tongue. This was just the sort of behaviour that was causing concern. Denise said, I invited you here to see if we could resolve this. I can see we are not going to be able to, so I will start an investigation. Because the other staff don't feel safe and you are unwilling to try and resolve the conflict you have caused, I'm going to stand you down on pay until the investigation is complete.
You can't like Denise. You just can't. So question 1, does Nancy have a general protections claim, and could she seek an injunction to stop Denise or anyone else investigating? So the answer is yes to both.
Yeah.
Denise unquestionably has formed a view. So there's no doubt about that. She's taken action which she had no proper basis to take. She's required things to be done like try and resolve this, which are improper. And she's treated her badly as a result of her pushing back on the completely flawed process. So it's definitely a general protections.
Yeah.
And if you had a decent union, they would be in front of the federal court getting an injunction to stop the investigation. And can I say, it's been successful a number of times in the past, where the process of investigation is so flawed and directed through not spite, but through pique, being annoyed by somebody, well, then I'll just do this then. At those times, you'll get an injunction against you. Because on the balance of convenience, you've got to stop it, which is the test injunction. If you allow this to go with someone with a preconceived view, and Denise represents the organisation, then she can't have fairness. Once you get an injunction, besides spending $50,000 or $60,000, you also can't deal with the person, because without the investigation, you can't have findings. So at that stage, Nancy can't be touched. Not good, is it, really? If Nancy felt she'd been psychologically harmed by Denise, would she have a solid workers' compensation claim if a doctor agreed she had a diagnosed psychiatric condition?
Yes, she would. So the threshold test injury in or over the course of employment, so she can demonstrate that through this meeting. And is there any defence of reasonable management action? There wouldn't be, because what she's done is not in any way, shape or form reasonable.
So it's interesting, because it's an investigative or resolution process, so it doesn't even apply. Because it's not dealing with the performance management or the discipline, you would have incredible trouble if there was a workplace lawyer on the other side who knew anything from being able to run the defence at all, because it's not in the performance management, it's in the finding of fact. And that means it just has to be in the subjective mind of the person to be enough. Now, you're lucky, most insurers don't know how to apply the law, and the regulator in Victoria most definitely doesn't know how to apply the law. So if you had done things fairly, you might still get up in a reasonable management action, but as a matter of law, you shouldn't be able to. I just raised that. Was Denise's conduct a breach of safety law? Yes, in so many ways. Section 21 and 22. Did she provide a safe place of work? No. Did she identify, just on what is reasonably practical, did she understand that what she was doing was a hazard? Well, it definitely is a psychological hazard, what she was doing. She was being unfair. So many things that are wrong with it. She's failing to provide clarity, all those things. So there's about 5 hazards that are thrown together. Okay. Did she understand the level of risk that attended that? No, she was ignorant of the risk she was causing. Did she try and control anyone? No, she didn't. In fact, she did the reverse. Pretty bad. So if something bad happened out of this, then WorkSafe would have a go at this, both for Denise and for the business. Because remember, there's an imputed connection. If Denise does something, the business is liable, unless it can show Denise did something that's so out of keeping with their expectation. She's head of people and culture. They'll never be able to raise that defence. So, this is reckless. These are hazards. I'm indifferent to the hazards. It could cause serious harm. Yep. Just imagine if this person went home, stood down, devastated by what's been said, no proper basis for it. It is actually untrue. And the person harmed. What?
Yeah.
It's reckless endangerment.
But this is actually happening, because we've got cases here today where this very scenario has happened.
That's why I'm raising it.
Yeah.
That's exactly why I'm raising it, because I don't think people understand that safety law is the governing law of employment law. It is the big law that sits above it.
Yeah.
And so I think Denise would be prosecuted, and so would the organisation. I think it could be reckless endangerment. And if it led to the death of Nancy, then it could be industrial manslaughter, because this is a breach of every piece of workplace law and safety law on the way through. Okay, let's go to the next one. Does Denise have to disclose who made the complaint? No, that's one of the things here. She has to disclose the nature of the circumstances around what is wrong, but she doesn't have to say, Kim told me.
No, that's
okay.
Right. She might work it out from the allegations.
Yeah, but particularly if the only two in the room makes it hard. What details did Kim have to disclose? I've put Denise. I didn't drink last night. What details did Denise have to disclose as allegations for the purpose of investigation or conduct counselling warning process?
Yeah.
What was said or done?
Yeah.
To whom, when, and where?
Yeah.
That's it.
Quite simple.
Not hard, is it?
No.
Was the stand down lawful?
No.
Absolutely not. There was no evidence at all properly presented of a true safety risk or of seriousness.
No.
So,
the only thing you could say out of that, she says the staff don't feel safe. So if that was genuine, perhaps it would be. But otherwise, there was nothing to suggest she was going to interfere with the process or interfere with the people involved.
Well, but even if they didn't feel safe, the nature of the allegations, to the extent they were raised, was not serious enough to meet the threshold for stand down. So I think Denise was a total Gumby. I enjoyed writing about Denise. All right, guys. Well, look, next week, what we do want to talk about next week, because we had a number of people talk to us and say, look, could you do something more focused on officers? So next week, we're going to really focus on officer liability.
Okay.
Not only in their responsibility around safety law, but more broadly around leadership and behaviour, but with a real focus on what happens to officers now, particularly with a change of attitude of both the regulator and courts. Okay? So it'll be good fun next week. I look forward to seeing you, and thanks for being here. Cheers.
Bye.
Yeah, thumbs up. That's what it says. Thumbs up.